The House Judiciary Committee hearing room hummed with tension as Congresswoman Jasmine Crockett adjusted her microphone. C-SPAN cameras panned across the chamber, capturing the packed gallery and the row of witnesses seated at the long oak table. At the center, Speaker of the House Mike Johnson, who had taken the unusual step of appearing before the committee to defend his controversial legislative agenda. Just moments earlier, Johnson had finished a polished 20-minute presentation about constitutional principles and the separation of powers. With the confidence of a former constitutional lawyer, he had lectured the committee on the original intent of the Founding Fathers and how his leadership was restoring proper constitutional governance. Republican members nodded approvingly while Democrats exchanged skeptical glances. Now, as Chairman Jim Jordan announced, the chair recognizes the gentlewoman from Texas, Miss Crockett, for 5 minutes of questioning. Something in the atmosphere shifted. Johnson maintained his composed smile as he turned toward Crockett, but those watching closely noticed his fingers tightening slightly around his pen. What happened next stunned everyone in the room. With a single meticulously crafted question just 27 words long, Congresswoman Jasmine Crockett would dismantle Speaker Johnson's carefully constructed constitutional authority, expose a fundamental contradiction in his legal philosophy, and leave him stammering in front of millions of viewers. By the time her 5 minutes ended, Johnson's credibility was in tatters, and footage of the exchange was already racing across social media platforms nationwide. Before we dive into exactly how Crockett orchestrated this devastating takedown with a single question, hit that subscribe button and drop a comment letting us know where you're watching from. Our upcoming videos will break down more of Washington's most explosive confrontations that the mainstream media won't analyze. This confrontation had been brewing for months, and the contrast between the two attorneys turned politicians couldn't have been starker. Speaker Mike Johnson, 52, had built his entire political brand around being a constitutional conservative. Before entering politics, he had worked as a lawyer for the Alliance Defending Freedom, a conservative Christian legal advocacy organization. His rise to the speakership after the chaotic removal of his predecessor had been swift and surprising, with many attributing his selection to his reputation as a constitutional scholar who could navigate difficult legal questions facing the caucus. Since taking the gavel, Johnson had frequently cited his legal background when pushing controversial legislation. As a constitutional attorney for over 2 decades, he would begin statements using his credentials to add weight to his positions. He regularly appeared on cable news programs where hosts introduced him as a constitutional expert, whose legal analysis carried special authority. His office walls displayed framed copies of the Constitution and the Declaration of Independence, visual symbols of his self-proclaimed expertise. Congresswoman Jasmine Crockett presented a dramatically different background and approach. At 42, the freshman representative from Texas had joined Congress after serving in the Texas legislature. Before politics, she had built her reputation as a civil rights attorney, representing clients in police misconduct cases and fighting for voting rights. Where Johnson spoke of original intent and textualism, Crockett emphasized evolving interpretations and the lived reality of constitutional principles in practice. Today's hearing had been convened to examine Speaker Johnson's controversial legislative agenda, which Democrats argued violated several constitutional principles despite his claims of constitutional fidelity. Johnson had agreed to testify, confident in his ability to defend his positions based on his legal expertise. He had arrived with binders full of notes and historical references, prepared for what he expected to be standard partisan questioning. What Johnson apparently hadn't expected was that Crockett had spent the previous night meticulously researching his legal career, public statements, and voting record. While other Democrats planned to focus on policy disagreements, Crockett had identified something more fundamental, a striking contradiction between Johnson's stated constitutional philosophy and his actual legal positions. Over the years, the stakes extended far beyond a single congressional hearing. This was a battle over who had the authority to interpret the Constitution, whose legal expertise would be valued, and which vision of American governance would prevail in the public narrative. For Johnson, maintaining his image as a constitutional authority was crucial to his effectiveness as Speaker. For Crockett, exposing contradictions in his positions would undermine the very foundation of his political power. As Crockett arranged her notes, the committee room settled into expectant silence. Republican members looked relaxed, confident in the speaker's ability to handle whatever questions came his way. Democratic members leaned forward, curious about their colleague's approach. None of them, not even Johnson himself, anticipated how thoroughly one carefully crafted question was about to change the dynamic of the entire hearing. "Thank you, Mr. Chairman," Crockett began, her voice clear and measured. "And thank you, Mr. Speaker, for appearing before the committee today. Before I ask my main question, I'd like to confirm a few points about your legal philosophy for the record." Johnson nodded confidently. "Happy to clarify my positions, Congresswoman. You've described yourself as a constitutional originalist and textualist." "Correct?" Crockett asked. "Yes, that's accurate," Johnson confirmed. "I believe we must interpret the Constitution according to its original public meaning at the time it was ratified. And you've stated numerous times that the Constitution should not be treated as a living document that evolves with changing times and social values." "Correct. That's right," Johnson replied, warming to a familiar topic. "The Constitution has a fixed meaning. If changes are needed, they should come through the amendment process, not judicial reinterpretation." Crockett nodded, making a note. "And would it be fair to say that you believe this originalist approach should be applied consistently to all parts of the Constitution?" "Absolutely," Johnson said with conviction. "Consistency is essential to constitutional interpretation. We can't pick and choose which parts to follow based on political preference." With those preliminary questions, Crockett had established the foundation for what was about to come. Johnson had walked directly into her carefully set trap, unaware that she was about to use his own words to completely dismantle his constitutional credibility. "Thank you for those clarifications, Mr. Speaker," Crockett continued, her calm demeanor giving no hint of the bombshell she was about to drop. "I have one substantive question for you today." She paused briefly, ensuring the C-SPAN cameras were focused on both her and Johnson, then delivered the question that would render the Speaker of the House speechless. "Given your commitment to strict originalism, can you explain why you believe the Second Amendment protects an individual right to bear arms when the Supreme Court didn't interpret it that way until 2008 in District of Columbia versus Heller?" More than 200 years after ratification, the hearing room fell completely silent. Several committee members blinked in surprise at the unexpected angle of attack. This wasn't the policy question Johnson had prepared for. It was a direct challenge to the consistency of his constitutional philosophy. Using one of conservatives' most cherished positions on gun rights, Johnson stared at Crockett for a moment, his practiced smile faltering. He reached for his water glass, taking a sip as he visibly gathered his thoughts. "Well, Congresswoman, the Heller decision simply recognized what was always true about the Second Amendment. The right to bear arms has always been an individual right." Crockett nodded thoughtfully. "That's interesting, Mr. Speaker, because for most of American history, including the first 217 years after the Second Amendment was ratified, federal courts consistently ruled it protected a collective right related to malicious service, not an individual right to own firearms for personal use. If you're an originalist, shouldn't you follow that original understanding?" The question hit like a precision strike. Several Republican members shifted uncomfortably in their seats. This was challenging Johnson on terrain where conservatives believed they had the strongest constitutional footing, using their own methodology against them. Johnson's response came more quickly this time, but with a noticeable defensive edge. The earlier courts got it wrong. The text is clear. The right of the people to keep and bear arms shall not be infringed. That's an individual right. So you believe courts can get it wrong for over 200 years about the original meaning of the Constitution? Crockett asked, her tone remaining conversational rather than confrontational. That seems to contradict originalist philosophy, which holds that the meaning was fixed at ratification and should be clear to those who study the historical record. She continued before Johnson could respond. And if we're looking at the text as you suggest, the full Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The militia clause seems quite relevant to the original understanding. The committee room had grown increasingly tense. What had begun as a standard oversight hearing had transformed into a constitutional law seminar where the self-proclaimed expert was struggling to maintain consistency. Democratic members were now watching with undisguised interest, while several Republicans were frantically flipping through notes, hoping to find something that might help the speaker. Johnson straightened his tie, his earlier relaxed demeanor now replaced by visible tension. The militia clause is prefatory, not limiting. It announces a purpose without restricting the right. Justice Scalia explained this thoroughly in Healer. Yes, in 2008, Crockett noted calmly, but we're discussing the original understanding at the time of ratification. If originalism is correct, how could courts, legal scholars, and legislators misunderstand this supposedly clear individual right for over 2 centuries? Doesn't that contradict the core originalist claim that the Constitution's meaning is fixed and discernible? The trap was now fully sprung. If Johnson maintained that the Second Amendment had always protected an individual right despite centuries of contrary interpretation, he was undermining the originalist claim that constitutional meaning is clear and fixed. If he acknowledged that constitutional understanding can evolve, he was contradicting his fundamental legal philosophy. Either way, his carefully constructed image as a consistent constitutional authority was crumbling in real time. Johnson glanced toward Chairman Jordan, perhaps hoping for an intervention, but found none forthcoming. The chairman himself seemed unsure how to rescue the speaker from this unexpected constitutional dilemma. The historical record supports the individual right's interpretation when properly examined, Johnson finally said, though his voice lacked its earlier confidence. The founders clearly intended. "I find that fascinating, Mr. Speaker," Crockett interjected smoothly, "because in your own legal brief in Sylvester Fiert Becerra, you wrote that constitutional rights must be interpreted in light of changing circumstances and evolving understandings. That sounds remarkably like the living constitutionalism you've repeatedly condemned." The committee room erupted in murmurs. Johnson's face visibly flushed as Crockett held up a printed copy of the brief he had authored. This was no longer just about the Second Amendment. It was about exposing a fundamental inconsistency in his entire constitutional approach. "That statement was specific to the context of that case," Johnson responded, his voice now noticeably strained. "My overall philosophy remains originalist. Does your originalism allows for evolving understandings when it supports gun rights, but not when it supports other rights?" Crockett asked. "That seems less like a consistent legal philosophy and more like a selective application of different theories to achieve preferred outcomes." With that question, the dynamic of the hearing had completely transformed. What had begun as a standard committee session with the speaker confidently defending his agenda had become a masterclass in exposing constitutional inconsistency, using just one carefully crafted initial question and precise follow-ups. Crockett had forced Johnson to contradict himself repeatedly on his most fundamental claim to authority, his constitutional expertise. The tension in the hearing room was palpable as Mike Johnson struggled to regain his footing. His earlier confident demeanor had completely evaporated, replaced by visible discomfort. He shuffled through his notes, clearly searching for talking points that suddenly seemed inadequate for the constitutional trap he found himself caught in. "Congresswoman, you're conflating different legal concepts," Johnson said, attempting to sound authoritative despite his obvious discomfort. "Originalism doesn't deny that applications of constitutional principles might address new circumstances. It simply maintains that the underlying meaning remains fixed." Crockett nodded thoughtfully. "I appreciate that clarification. So, would it be fair to say that you believe the Constitution's principles can be applied to circumstances the founders couldn't have anticipated?" "Yes, within reasonable boundaries," Johnson replied, seemingly relieved by the more general question. "That's interesting," Crockett responded, "because when the Supreme Court applied that exact approach to recognize privacy rights in Griswold versus Connecticut, or equal protection for same-sex marriage in Oberfell versus Hodges, you condemned those decisions as judicial activism and living constitutionalism gone wild. Yet you celebrate when the same interpretive approach is applied to extend Second Amendment rights beyond what was recognized for most of American history. The committee room fell completely silent. Several Republican members looked down at their notes, visibly uncomfortable. Democratic colleagues tried to hide their surprise at the effectiveness of Crockett's approach. Rather than arguing policy positions, she was exposing a fundamental inconsistency in Johnson's entire legal philosophy. Those cases involved creating new rights not found in the text. Johnson countered, his voice taking on a defensive edge. The Second Amendment explicitly mentions the right to bear arms. The 14th Amendment explicitly mentions equal protection under the law. Crockett replied calmly. T2, yet when courts applied that text to protect same-sex couples, you called it activist judging. When courts applied the Second Amendment to protect individual gun ownership, a right not explicitly stated in the text and not recognized for over 200 years, you called it proper originalism. The inconsistency seems clear. The C-SPAN cameras caught Johnson loosening his tie slightly as beads of sweat became visible on his forehead. Chairman Jordan glanced at the clock, perhaps hoping to rescue the speaker, but Crockett still had over 2 minutes remaining in her allotted time. "Mr. Speaker," Crockett continued, her tone remaining professional and measured, "I'd like to enter into the record this 2019 speech where you stated the Constitution's meaning was fixed at the time of ratification and doesn't change with judicial fashion or political preference. Do you stand by that statement?" "Of course," Johnson replied, seemingly grateful for what appeared to be a softball question. Crockett nodded. "Then, I'm struggling to understand your position on the Second Amendment. If the Constitution's meaning was fixed at ratification and doesn't change, how do you explain supporting an interpretation that wasn't recognized for over 2 centuries after ratification? Doesn't that contradict your own stated principle?" The trap had closed completely. Johnson found himself in an impossible position of his own making. If he maintained that the Second Amendment always protected an individual right despite centuries of contrary understanding, he was undermining the core originalist claim that constitutional meaning is clear and fixed. If he admitted that interpretations can evolve, he was contradicting his fundamental legal philosophy and opening the door to constitutional approaches he had spent his career condemning. "The historical evidence supports," Johnson began, but his voice trailed off as he seemed to recognize the corner he had backed himself into. "Mr. Speaker," Crockett said, her voice still composed but now carrying unmistakable authority. "Respectfully, what the evidence suggests is that you apply originalism when it leads to outcomes you prefer politically and abandon it when it doesn't. That's not constitutional fidelity. It's constitutional convenience." The gallery erupted in murmurs. Several journalists were frantically typing on their laptops, recognizing the historical significance of what they were witnessing. A freshman congresswoman had just systematically dismantled the constitutional credibility of the Speaker of the House using nothing but his own words and positions. Johnson's response when it finally came was telling in its weakness. "The courts have settled this matter. Heller is the law of the land." "Yes, it is," Crockett agreed. "Just as Obergefell is the law of the land regarding marriage equality, and Griswold is the law of the land regarding privacy rights. Yet you celebrate one while condemning the others. Despite all three representing evolving interpretations of constitutional text, the difference appears to be not your legal philosophy, but your political preferences." She glanced at the chairman. "Mr. Chairman, I have no further questions. I'd like to enter into the record the Speaker's 2019 speech on originalism, his legal brief in Silve Becerra advocating for evolving understandings of constitutional rights, and his public statements condemning the Obergefell and Griswold decisions as judicial activism." "Without objection," Chairman Jordan muttered, clearly eager to move on. As the clerk gathered Crockett's documents, the committee room remained unusually quiet. Republican members avoided making eye contact with the Speaker, while Democrats exchanged glances of barely contained amazement. Johnson himself sat stiffly in his chair, his earlier authoritative presence diminished. The constitutional expert had been exposed as constitutionally inconsistent by a freshman representative with one devastating question. The C-SPAN cameras captured it all. Johnson's confident entrance, Crockett's precise questioning, and the steady unraveling of the speaker's credibility in real time. Without raising her voice or making a single personal attack, Congressman Crockett had accomplished what countless partisan attacks had failed to do. She had challenged the very foundation of Johnson's authority using nothing but his own words and principles. Within minutes of the exchange, clips began flooding social media platforms. Crockett question. Johnson stumped, and constitutional consistency became top trending topics nationally. The clip of Crockett asking her initial question about the Second Amendment and originalism had already reached over 1 million views on Twitter within the first hour. Political commentators across the spectrum scrambled to analyze what they had just witnessed. On CNN, a panel of legal experts dissected the exchange. "What we just saw was a masterclass in constitutional cross-examination," said a former federal judge. Congresswoman Crockett identified the fundamental contradiction in the speaker's legal philosophy and exposed it with surgical precision. She didn't attack him personally or engage in partisan rhetoric. She simply used his own stated principles against him. MSNBC ran a Chiron reading, "Speaker Exposed." Johnson's constitutional contradictions laid bare. Even on Fox News, legal analysts struggled to defend the speaker's inconsistent positions. "John Johnson walked into a perfectly executed trap," admitted one conservative commentator. "When you build your entire political brand around constitutional originalism, you can't apply it selectively without undermining your own credibility." As the hearing continued, Johnson's demeanor remained noticeably subdued. His responses to subsequent questions lacked the confident authority he had displayed earlier. Republican members attempted to throw him softball questions to help him recover, but the damage had been done. Every answer he gave now seemed tinged with the awareness that his constitutional methodology had been exposed as inconsistent. Outside the hearing room, journalists swarmed Crockett as she exited. "Congresswoman, did you anticipate the speaker would be unable to reconcile his positions?" one reporter called out. Crockett's response was measured and professional. "My job on the Judiciary Committee is to ask substantive questions about constitutional interpretation, especially when it forms the basis for legislative decisions affecting millions of Americans. Consistency in legal philosophy isn't a partisan issue. It's fundamental to the rule of law." Her refusal to gloat or frame the exchange in partisan terms only enhanced the impact of her questioning. This hadn't been a typical congressional gotcha moment. It had been a substantive exposure of constitutional contradictions by someone clearly fluent in the subject matter. The political fallout was immediate and far-reaching. Democratic leadership, recognizing the significance of the moment, began featuring clips of the exchange in their messaging about Johnson's speakership. How can someone lead the House when their most fundamental principles shift based on political convenience? Asked the House Minority Leader in a press conference that afternoon. For Republican leadership, the damage girl efforts began immediately. Johnson's office released a statement claiming that Crockett had taken the speaker's positions out of context in a partisan attempt to distract from substantial policy issues. But this defense rang hollow against the visual reality of Johnson's inability to reconcile his own contradictory statements when confronted with them directly. Constitutional law professors began incorporating the exchange into their teaching materials. Harvard Law School's professor of constitutional interpretation told the Washington Post, "This will become a textbook example of exposing inconsistent legal methodologies, regardless of one's political positions." The exchange revealed a fundamental problem in contemporary constitutional discourse: the selective application of interpretive methods based on desired outcomes. The impact extended beyond academic circles. Conservative legal organizations that had championed Johnson as a constitutional authority found themselves in an awkward position. Several issued carefully worded statements reaffirming their commitment to originalism without directly mentioning Johnson or the hearing. The Federalist Society, which had frequently featured Johnson as a speaker, quietly postponed his scheduled appearance at their upcoming symposium. For Johnson personally, the exchange represented a significant blow to his carefully constructed image as a constitutional expert. His effectiveness as speaker relied heavily on his perceived authority on constitutional matters. Now, whenever he invoked originalism or constitutional fidelity, critics would point to Crockett's questioning as evidence of his selective application of these principles. Media coverage of the confrontation continued for days, with legal analysts from across the political spectrum weighing in. The New York Times published an analysis titled "When Originalism Meets Political Convenience: The Johnson Contradiction," while the Wall Street Journal ran a more sympathetic piece, arguing that Johnson's position, while imperfectly articulated, reflects nuanced originalism. But even the latter conceded that the speaker had failed to effectively explain this nuance when directly questioned. Perhaps the most telling indicator of the exchange's impact came 2 weeks later during a press conference when a reporter asked Johnson about a constitutional question related to pending legislation. The speaker, once eager to expound on constitutional principles, responded briefly before deferring to the Judiciary Committee chairman. His days of confidently lecturing about constitutional originalism had been significantly curtailed by one precisely crafted question. For Crockett, the exchange elevated her national profile dramatically. Interview requests poured in from major networks and publications. Law schools invited her to speak about constitutional consistency. Democratic leadership took notice of her effectiveness in committee hearings. Donors reached out, seeing her as a rising star worth supporting. Within her Texas district, constituents organized watch parties to view clips of the exchange, proud that their representative had made such an impact. When Crockett finally gave an in-depth interview about the exchange on a Sunday morning talk show, she maintained the same measured approach that had made her questioning so effective. This wasn't about partisan politics, she explained. It was about constitutional consistency. We can have good faith disagreements about interpretive methodologies, but we should at least apply our chosen methodology consistently. Otherwise, we're not engaging in constitutional interpretation. We're engaging in constitutional rationalization. Asked if she had planned the question specifically to trap Johnson, Crockett smiled slightly. I prepared thoroughly, as any good attorney would. Speaker Johnson has made his constitutional expertise central to his political identity. When someone does that, it's entirely appropriate to test whether their constitutional positions reflect consistent principles or convenient politics. The confrontation between Jasmine Crockett and Mike Johnson would be referenced in political science and law school classes for years to come. It became a case study in effective congressional questioning, the importance of constitutional consistency, and the dangers of building a political brand around principles applied selectively for the broader political landscape. The exchange highlighted a growing sophistication in constitutional discourse. Surface-level invocations of originalism or living constitutionalism were no longer sufficient. The public was beginning to recognize and demand consistency in legal philosophy. Several members of Congress from both parties began more carefully framing their constitutional arguments, aware that inconsistencies might be exposed in similar fashion. 6 months after the hearing, when Johnson appeared at a conservative legal conference, he was still being asked about the exchange with Crockett. His answers had evolved into a more nuanced position, acknowledging that originalism requires careful historical analysis that might yield surprising results in some cases. This modified stance, while more defensible intellectually, lacked the simple certainty that had previously characterized his constitutional pronouncements. For Crockett, the lasting impact went beyond personal political advancement. She had demonstrated how substantive, well-prepared questioning could cut through political performance and expose fundamental contradictions. In subsequent committee hearings, witnesses and members alike became noticeably more careful when she began her questioning, aware of her reputation for identifying inconsistencies with laser precision. The confrontation between Jasmine Crockett and Mike Johnson ultimately represented something rare in contemporary politics. A moment when substance triumphed over style, when carefully crafted questions revealed more than rehearsed talking points, and when constitutional consistency proved more important than constitutional convenience. With one question, Crockett had not just challenged a speaker. She had elevated the entire discourse around constitutional interpretation in American politics. If you found this breakdown of how Congresswoman Crockett destroyed Speaker Johnson with just one question enlightening, don't forget to hit that like button and subscribe to our channel. Drop a comment below telling us which political confrontation you'd like us to analyze next. Turn on notifications so you won't miss our upcoming video on 5 questioning techniques Crockett uses that you can apply in your own life. Thanks for watching, and we'll see you in the next